Hello, I'm Lance LoRusso with LoRusso Law Firm and the founder of the Blue Line Lawyer Institute. On February 22nd, 2019, Little Rock police officer Charles Starks was forced to make a decision that no officer wants to make. Fortunately, he was able to survive a deadly force encounter, but had to use deadly force to protect himself and stay alive while effecting an arrest. Due to a lot of political circumstances, he was terminated. A great lawyer in Little Rock, Arkansas, named Robert Newcomb, defended him, and the City of Little Rock Civil Service Commission elected to uphold his termination. Robert got me involved, and I was honored to be a part of that case. I'm licensed in Arkansas, Georgia, and Tennessee. When I got involved in the case, we appealed it to the Circuit Court in Little Rock in Pulaski County. Through 3 trips to the Court of Appeals, and this last trip on December 4th, 2024, which you're about to see. You're about to see the oral argument that took place when we secured full back pay and the restoration of Officer Starks to the Little Rock Police Department. Now, it's important to understand a couple of things here. This took 5 years, more than 5 years, almost 6 for Officer Starks to be cleared. Second, the Circuit Court and the Appellate Court stated that Officer Starks did absolutely nothing wrong and his actions were completely legally justified on February 22nd, 2019. So take a moment. This is an oral argument in Appellate Court. The first person you'll see speaking is the city attorney for the City of Little Rock, who was attempting to keep Officer Starks from getting his back pay. And then I will be arguing after that. One of the things that's important to recognize is that the circumstances of this case unfortunately forced Officer Starks to leave law enforcement. He is an absolutely fantastic human being from a great family, and we were honored to represent him. Thank you.
All rise. Hear ye, hear ye, hear ye. Arkansas Court of Appeals is now in session. All persons having business before this honorable court shall be given to you to the May God save the United States, State of Arkansas, and this honorable court. You may be seated.
Good morning. Today our court announces the disposition of 46 appeals. Information about these appeals is available to the public in the clerk's office in room 130 and on the judiciary website. The oral argument today is CV 23-226, Little Rock Police Department and the City of Little Rock versus Charles Starks. This is from Pulaski County. Counsel for the appellant is Mr. Edding. Is that correct?
That's correct, Your Honor.
Counsel for appellee is it LoRusso? LoRusso?
LoRusso.
LoRusso? Mr. LoRusso?
I'm here with Mr. Newcomb as well. I'll be arguing.
Okay. And the appellant's reserving 5 minutes. Everyone ready to go?
Yes, Your Honor.
All right, appellant, please proceed.
Good morning. My name is Edding, and I practice here in Little Rock at the law firm of Friday, Eldridge & Clark. And it's my pleasure this morning to appear before this panel to prosecute this appeal on behalf of the Little Rock Police Department and the City of Little Rock, and may it please the court. Just by way of background.
Excuse me, Mr. Eddings, my clock is not running. Do I need to do something to start my clock here?
Good catch. Good catch. Yeah, the clerk was over there asleep.
Oh, now it's going.
All right.
I'll give you 4 seconds back.
Thank you. I may need it. Just by way of background, and this case has been up on appeal before, but very briefly, Mr. Starks was terminated by the Little Rock Police Department on May 6, 2019, for violation of General Order 303, Roman number 2, capital E2, and you'll hear both parties, I suspect, talk a lot about that general order. But what that general order provides is that, or instructs, is that officers will not voluntarily place themselves in front of an oncoming vehicle when deadly force is the probable outcome. In situations like that, when confronted by an oncoming vehicle, officers will move out of his path if possible rather than fire at the vehicle. Now, after Mr. Starks' termination on May 6, 2019, he appealed that termination to the Little Rock Civil Service Commission, which upheld that termination. Mr. Starks appealed the Civil Service Commission's decision to the Pulaski County Circuit Court, where the Circuit Court reversed the finding that Mr. Starks voluntarily placed himself in the path of an oncoming vehicle. But he also...
I think that's a good place for me to ask my first question. Let's talk about what voluntary means. The way I read this case, and it's a terrible case, but General Order 303 introduces the term voluntarily, which is not a term with which we are generally familiar. So help me out and tell me what your position is. What does the term voluntarily mean in 303?
Okay, my position, and as we'll see in Mr. Starks' testimony before the Civil Service Commission, is that voluntary means actions that were conscious, purposeful, and done with intent. That is the appellant's position that makes Mr. Starks' actions voluntary.
Those are nice legal terms. Where'd they come from? I don't see the term purposeful, knowingly, all those terms that we deal with every day. I don't see those terms in this regulation or this order, which gives me a hard time to know what voluntarily means. So help me out on that.
Right. Those are dictionary synonyms of the word voluntary. And it's true that those words don't appear in the general order, but I think that the department, as well as the court, is allowed to use its common sense as to the everyday use of these words. So, but going back on remand.
Well, I'm not ready to go back yet.
Okay.
So let's go back to voluntary again, and I really want to hear both sides on this. Does the lack of any further definition make this ordinance ambiguous? And are we trying to interpret an ambiguous regulation or an ambiguous order?
You know, I don't think so in this case, particularly when going through Mr. Starks' testimony before the commission and before the trial court, where that testimony reveals that, you know, Starks had a conscious awareness of the circumstances. He had, when he moved in front of the oncoming vehicle, his testimony demonstrates that he had an intent to move in that direction, and he also had a purpose for moving in that direction. And I think that makes his actions voluntary.
Does his conscious awareness of an emergency situation not come into what constitutes voluntarily?
I think to some extent it does. And I think that again, doesn't, I think that goes to the reasonableness of his actions. But this court has determined before remitter that that's not the issue here. The issue solely is whether his actions were voluntary.
So if you use the Webster's dictionary definition of voluntary, it's proceeding from one's own free choice or consent rather than as a result of duress, coercion, and deception. So under that definition of voluntary, then the duress would come into play and whether or not it was voluntary. Is that correct?
Duress could come into play. But I think that what we're looking at here is, and you know, there's this idiom that a picture's worth 1,000 words. So the picture could, you know, illustrate the circumstances far better than I could. But in this situation, we've got a video. We've got several videos in the record And those are worth much more than 1,000 words.
Can I ask you, I've watched all these videos, and as I was reading a couple of these opinions and decisions, they sound like these videos are very clear that you can see everything that goes on. I didn't see a good video that I thought showed the entire episode from start to finish. Is there one video that you believe is better than the others? One exhibit that actually shows the episode from start to finish?
From start to finish, there is a video where there are 4 quadrants.
Yes.
And I think that if you look at those simultaneously, that's probably the best vantage point.
Okay.
That the commission had, the trial court had, and that's before the court here.
Thank you.
And I think that, and going back to those videos, there's a barbershop video. I think it's in the top right quadrant of those videos. To me, I think that that's the best viewpoint in determining whether Officer Starks' actions were voluntary or not. And I say that.
What definition did the trial court use of voluntariness?
The trial court did not use a definition of voluntary.
Does it have to?
I think that the trial court.
Because my job is to determine if he clearly erroneous or not.
Right.
I don't get to make up this whole thing again. I have to specifically point out where he is clearly more than 50% wrong.
Right.
Correct? Mm-hmm. What was his definition?
I don't think that the trial court used the definition of voluntary.
Now, he was told by this court to do that.
He was.
Are you saying he didn't do that?
I'm saying that when this
Was he asked to do that
he was asked.
by the council at the time? Does anybody demand that he define voluntariness below?
No.
Okay, thank you.
No, that was not an act of the court. But I think, though, going back and looking at the testimony, what it appears to me, though, is if you look at the testimony of Officer Starks and juxtapose that testimony of these, and I'm almost certain that the appellants will talk about these 16 other witnesses who testified that said that his actions were not voluntary. So I think that, and that's part of the appellant's argument, that the trial court didn't give the greater weight of the evidence towards Officer Starks' testimony. It believed these other folks' testimony. And it's the appellant's position that the most credible witness to testify as to what was going on in Officer Starks' head, what was going on in Officer Starks' mind, is none other than Officer Starks. Because if you look at those videos, he was the only officer on the scene. He was the only officer who made the determination that and there was no officer there when he made this determination. He was the only officer who made the determination that he had to cross over in front of an oncoming vehicle, and he had a purpose. And his testimony reveals that he had a purpose. He knew where he was, and he knew where his own patrol car was in relation to that oncoming vehicle. So that demonstrates that his actions, he was conscious. He was conscious of where he was. He was conscious of where the oncoming vehicle was. And he was also conscious of where his own patrol vehicle was. He also had purpose. His testimony was over and over again in the record that the purpose of him moving in front of that vehicle was to get back to his own vehicle because he thought that that's where he was safe. And I think that, all of those, a combination of all of those facts clearly show that, rightly or wrongly, we can argue about, the tactics that he used, but this court has said that we don't analyze this case under a reasonableness standard. But looking at all those facts, it's clear that Officer Starks voluntarily chose this path versus another path. And we think that the trial court erred in not considering the testimony of others over the testimony of Officer Starks. And I want to point out a couple of instances in the record that underscore the unreliability of the trial court doing that. There was an officer, Sergeant Tori Trammell, and this is in the record at 1176, 1177. She was being asked to watch the video when Officer Starks pulls into the parking lot, and she was asked if she thought that Officer Starks could still see the car, the suspect car moving, parking into the parking space. Sergeant Trammell testified that she had no idea what Officer Starks would have seen. She doesn't know any of the facts, what he knew. She doesn't know what he saw, doesn't know what he knew, and why he did anything while out there on that lot. But yet again, even still, Sergeant Trammell testified that she didn't think that, Officer Starks' actions were voluntary. And then there's one more point in the record that I want to point out that underscores the unreliability, relying on what other officers had to say about Officer Starks' actions as opposed to relying on Officer Starks' testimony about his own actions. Officer Heath Atkinson, and this is in the record at 815 and 816. Officer Atkinson testified that he didn't think that Officer Starks voluntarily moved in front of the oncoming vehicle because he thought that he ended up there involuntarily because Officer Starks lost his balance and fell in front of the vehicle. But again, there's time and time in the record where Officer Starks testifies that he was conscious of where he was, he had a purpose and intent to move across in the path of that oncoming vehicle, and his purpose and intent was to get back to his patrol vehicle. For example, on
Mr. Eddings, if I can just, for the sake of argument, say that he did violate General Order 303, much like the commission found that Officer Simpson, the second officer on the scene, also violated General Order 303 with the use of his vehicle. He was excused under 104, General Order 104. How is General Order 104 not applicable to Officer Starks?
Well, primarily because Officer Starks has never argued that not before the Civil Service Commission, not during the internal affairs investigation of this fact, this incident, nor before the trial court that his actions were subject to an exception for deviation from the general orders. So that's in my view why that exception doesn't apply to Officer Starks, and it applies to Officer Simpson.
But at the time of the occurrence, that order would have applied to him, correct?
If he asserted it did, I mean, it was certainly available to him to assert, but that's never been an assertion of Officer Starks.
Did Officer Simpson assert that order?
I believe so.
Okay. And he did that before the commission?
Officer Simpson never came before the commission. His discipline never came before the commission, but he did that during the internal affairs investigation. He was never subject to discipline before the commission.
But as we're reading these general orders, and you read 104, realizing that there are some circumstances that would cause an officer to deviate, and you agree that the deadly force was used prior to the officer moving in front of the car. Would you agree with that?
I would say that the deadly force was used because the officer was in front of the car. So I'd have to disagree with your assertion that the deadly force was used prior to the officer moving in front of the car.
So were there not shots fired while he was beside the vehicle, and then shots continued to be fired after he?
That's correct. That's correct. But the testimony is, and Officer Starks' testimony is, that he knew that the only way that vehicle could escape was by turning left towards him. Officer Starks' testimony is also that he saw that those tires were turned left towards him. And this is why I disagree with you that the shots weren't fired before, after he was in the path of the oncoming vehicle, because the Officer Starks chose to stand at a place where he knew only the car could move to escape, but yet he chose to stand there. And once the car did move, Officer Starks at that point, by policy, was permitted to use deadly force. But that does not, again, negate Officer Starks' responsibility to move out of the path of the oncoming vehicle. As a matter of fact, the general order requires, if it's possible to move out of the path of the oncoming vehicle rather than shoot, then the officer must do so.
Mr. Eddings, you're into your rebuttal time. I don't want to stop you. You're free to continue, whatever.
I'd like to preserve the 4 minutes that I have left, I believe.
Okay.
Thank you.
Mr. LoRusso?
May it please the court. My name is Lance LoRusso, together with Robert Newcomb. I'm honored to stand here representing Charles Starks, who is also in the courtroom. This is a case involving a use of force by a law enforcement officer and a violation that was found considering his actions. And I respectfully point to the court. It took longer for me to introduce myself than it did for this entire transaction to take place. All three of you have hit on the essential issue of voluntariness. He was faced with a Hobson's choice. And Judge Barrett, you're absolutely correct. Deadly force was used, but not as Mr. Eddings pointed out. Deadly force was used against a uniformed Little Rock police officer by hitting him with a car before he made the decision to move. Do you get shot or do you get hit by a car? In no other circumstances, in no other profession would we say that the movements to safety, as the appellant admitted, were voluntary. Now, respectfully, Judge Hickson, courts do deal with this voluntary issue a little bit. We deal with it with undue influence. We deal with it with adhesion contracts. We deal with it with issues surrounding fraud. And all of those have to do with whether or not a person made a voluntary decision that they can be bound by.
So what is Judge Fox's definition of voluntariness?
Judge Fox was never asked to
He was
define
told to. He was told by this court to use voluntariness. We didn't give him a definition, but we did tell him to use the voluntary standard. Did we not?
Respectfully, Your Honor, I have read through Judge Barrett's opinion.
Yes.
And he was not specifically told to define what voluntary was.
He was not.
He was told to
Use that
apply
standard.
the standard, which was set out by the Little Rock Police Department.
Are we not to assume that the circuit judge followed our instructions?
Yes, you are.
Absolutely. Thank you.
And, Your Honor, to your point, there is overwhelming evidence that the judge, number one, did a complete de novo review following Judge Barrett's November 21 order. Number two.
Using voluntariness.
Yes.
Okay. I
And
want
number
to
two-
reiterate that every time we do.
I understand, sir. And then number two, he said, in his words, he reviewed the record stem to stern. Number two, he clearly stated in his order, and he clearly stated in the record of that appearance in January of 23, that he applied the standard this court told him to apply. And you know, there's an opinion that the appellant relied upon, and it's Little Rock versus Newcomb. And there's a really interesting point out of that case. The findings and conclusions of the trial judge show that he carefully and fully considered the evidence before the commission, along with additional testimony originally heard in the circuit court. We are unable to say that these findings are against the preponderance of the evidence. That's what you have here. Now, respectfully, I would point the court to 15 out of 16 witnesses who testified in the Civil Service Board hearing. It is some 400 or 500 pages of a transcript. Look at then Captain Helton. Starts at about 60, page 60 in the record of the November hearing. The hearing was divided in 2 days. He testifies for about 30 or 40 pages. Clearly, he says there was no violation. To Judge Barrett's point, he states that deadly force was used, therefore the actions going back to his car, number one, is what he was trained to do, and number two, were not voluntary because this was a fluid situation. Deadly force had been used against him. Nothing about that was voluntary. That's number one. Number two...
That's his opinion. That's not factual.
I'm sorry.
The facts, I mean, that's his opinion.
Yes, sir.
So, Mr. Edding made a point that the two important factual things we have are the videos and Officer Stark's testimony. Other than that, it's just people's conclusion of what they think should or should not have happened.
Absolutely.
Do you agree with that?
I do, but to that point, Your Honor, video will never show you the fear in the officer's heart that Officer Starks testified to, that he was hit with a vehicle and recognized that he was in trouble. He fired. He recognized he was hit again. He recognized that the suspect was reaching for a weapon, and he believed, and in fact he was reaching for a weapon, and he retreated to the only safety that he found and that what he was trained to do. That is the testimony from the Civil Service Board hearing. That is uncontroverted. So to say that Charles Stark said this was a walk in the park and he was never in fear and this was a voluntary action just misconstrues the record, and Judge Fox got it right. I think when we go through the testimony of Mr. Helton, Captain Helton then, and we look at the rational review, the de novo review, which is an original action. In Arkansas, this is considered an original de novo review, as if the record is there and the court is making credibility determinations. Then Captain Helton is now the chief of the Little Rock Police Department. Can the Little Rock Police Department stand up here and tell you that if Judge Fox relied solely on his statement, solely on his testimony, that that was clearly erroneous? There is nothing in this record, there is nothing in the opinion to indicate that, number one, the court did not do a de novo review following your order, and number two, that the judge did not look at the facts and determine them to be based on the preponderance of the evidence. There is nothing to leave this court, as Hubbard states, with a definite and firm conviction that a mistake has been made. If we go to the facts of this case and we start with the issue of where the circumstances were at the time that they were placed in front of Officer Starks, Judge Barrett, you absolutely hit the nail on the head with a subjective belief being relevant. He was trying to stop a car chase. He was looking for a stolen vehicle that had been verified as stolen. He was surprised when he went into the back of the barber shop, and he had a matter of seconds to decide what to do. He blocked the vehicle as best he could, and he tried to contain the situation where it was. There is no doubt, and we cited the Lamb versus State case, there is no doubt that Mr. Blackshire was under arrest. Not free to leave, full-blown probable cause arrest. And in the analysis, over and over and over again, and in the appellant's brief, Mr. Blackshire's legal obligations to obey the 12 orders to get out of the car in 25 seconds, to not move his vehicle, and to submit to the officer's lawful orders and be taken into custody is just disregarded.
What should Officer Starks have done, in your opinion, once he notices the wheels are moving, and they're barely moving? At that point in time, what did General Order 303 require Officer Starks to do?
He backed up, and the general order would require him to stay alive. That is what all of the general orders require them to do, is police, effect arrests, and stay alive doing it. He is closer to that car by half the distance than I am to you. So this notion that he's supposed to evaluate after someone's bumped him with a car, which way are the wheels turning? Where can I go? If you look at that barbershop video, the only safe haven for him is his car. And every one of those witnesses testified, including Helton, who was the director of training, that car is ingrained in them to be a position of safety. And if he was going to be shot at, he wanted to be behind that engine block. That's what officers are trained to do.
Is Order 303 applicable to this type of episode?
No. And nobody has ever asked that question. Respectfully, Your Honor, this absolutely has nothing to do with this episode.
Explain why.
In the Civil Service Board, we saw these rules and regulations and policies twisted 12 ways till Sunday. Well, it was a traffic stop. It wasn't a traffic stop. It was an oncoming vehicle when he pulled up. As Judge Barrett pointed out in her November 2021 order, it was a parked, stolen vehicle. It was not oncoming.
Was that argued to the trial court below?
I'm sorry?
Was that argued to the trial court below?
Yes.
It was.
Yes. He did not violate the policy.
The ruling was?
The ruling was that in the new ruling,
it didn't apply.
It didn't. Well, it's interesting, Your Honor. He said he didn't violate it.
I can't find where that was argued, and the judge said it never applied.
We said that it wasn't applicable for 3 reasons in our arguments. Number 1, he did not voluntarily place himself in front. Number 2, this was not an oncoming vehicle. And number 3, deadly force was not the probable outcome. So it was argued, perhaps inartfully, as I'm doing it here, but to presume I'm doing it artfully now. Yes. But that's what we pointed out. There's 3 elements to this policy. Number 1 is voluntary movement. We've explored that. Number 2, was it an oncoming vehicle? It wasn't an oncoming vehicle when he first approached it, and it was not an oncoming vehicle when he backed away from it. It was Mr. Blackshire who turned the car into a uniformed law enforcement officer, committing an attempted murder and aggravated assault, a felony of the highest order in any state. Facing a uniformed law enforcement officer giving commands when you are under arrest and offering felony violence towards that officer is the highest crime you can commit. And he did it over and over and over again. And at that point, Officer Starks had to make a decision. I've got to get to a position. And when we talk about the decision he had to make, the time between the last shot at the side of the car and the first shot on the hood is 0.2 seconds.
I would argue killing a judge would be just as high, but we can move on.
I'm sorry, sir.
I would argue trying to kill a judge would be just as high, but I digress.
Perhaps higher.
Yes, perhaps, exactly. But go ahead.
I want to carry that for a second further.
Okay.
Because there's been a lot of supposition about, well, Officer Starks should have tried to see what his intentions were. He really didn't know if there was a gun because he didn't see a gun. And I would submit to you to that hypothetical, Your Honor. If someone charged this bench right now, I don't think you would ask these officers to assume beneficence in their actions. You would expect them to act quickly. You would expect them to act about what the possible outcomes could be and anticipate staying alive and protecting people, what they're sworn to do. When this court looks at the issues that were faced by Officer Starks at this point, and you look at the time frames that took place, Judge Fox, in paragraph 3 of his January 2023 order, stated specifically, and I would say that it is a finding of fact, even though he wasn't asked to do it, that specifically he did not voluntarily place himself in a position of an oncoming vehicle in violation of the general order. He has to be able to make a choice. Deliberate action, just like these duress cases, just like undue influence, they all involve the deliberate action of an individual. The question was whether or not subjectively they had the opportunity to make that choice voluntarily. The difference all of those cases have, all of those matters that this court normally handles, they weren't done under time compression. From the time, as I stated, from the time that Officer Starks got out of his car to the time that Officer Simpson came over the curb and stopped the actions from taking place and stopped the vehicle is 58 seconds. The shots that were fired, and I want to point out, it's tragic this man lost his life. Loss of life is always a tragedy. But not a single person has said that the use of deadly force was inappropriate in this case. And to your point, Judge Barrett, as far as I know, Officer Simpson was never charged with a violation of any general order or any policy. So to say that it was explored in the internal affairs file, it was explored here. And if you look at the record, the irregularities in how this case was handled after the internal affairs investigation are set out in the record, that it was sustained before it was asked for comment.
Am I on a wild goose chase, or are we not trying to resolve an ambiguous language in a order and should proceed along trying to interpret any ambiguous document and use our usual construction, construing against the drafter, ordinary use, all those construction AMIs that we're used to?
It's interesting, Your Honor, if I can turn a phrase on the construction. If you look at the four corners of this general order that the City of Little Rock decided to charge him with, if it's ambiguous, the ambiguity falls to them. They wrote it, they adopted it, they promulgated it, they handed it to these officers, and they decided what to discipline him on. I do believe it's not only ambiguous, it is unworkable. As Judge Barrett pointed out, the definition of an emergency situation is what you see depicted on that video. It is a nightmare of every law enforcement officer. And but for the grace of God and perhaps Officer Simpson, Little Rock would have buried a police officer that day. And the bottom line, when you talk about the ambiguity in this statute, it's not only charged again, but the court cannot ignore the realities of human performance and human reaction. You know, Justice Oliver Wendell Holmes famously said, detached reflection cannot be demanded in the face of an uplifted knife. But that is exactly what the city has done. They have literally said you were attacked with a vehicle and someone was trying to draw a gun while you were trying to make a lawful arrest, and we're going to fire you because we don't like where your feet were planted. We're going to take that video and dissect it. And it's a bit disingenuous to say that they should rely on Officer Starks, who is focused on the threat in front of him, and disregard what anybody else said, including the director of training and his trainer. It's disingenuous to say he knew all of these circumstances and had absolutely a window of time to make this decision. He didn't. Is it ambiguous to a point where it can't be enforced? The court's going to have to decide that. In this circumstance, there's no doubt that his actions were not voluntary.
Go back for a minute. You raised a question on the, it doesn't describe what oncoming vehicle means.
Yes, sir.
And that 303 doesn't even apply to what we have here. What scenario is 303 tailored to cover?
There are two, possibly three people in the command staff that were asked that question in the civil service. It applies to a situation where an officer gets to a scene. And I think they used the example of I think it was Finks. Used the example of officer gets to a convenience store and a shoplifting has occurred. He sees the suspects getting into their car, and he stands in front of the car and says, "Don't move." Now he has voluntarily placed himself in front of a vehicle and a suspect that is going to flee, and he knows they're going to flee, and deadly force is the probable outcome, because if they hit him, he's justified in shooting. That was asked in the Civil Service Board, and that was explained. That is the scenario, and that has nothing to do with the scenario we have here. And that is why I say it doesn't apply.
Thank you.
This case has gone on since February of 2019. The notion that there is some impropriety by an officer who makes every effort to determine that a car is actually stolen before trying to find it, who does everything he can to find that vehicle, and then tries to prevent a chase. And I am sure that after a year of being on the bench, this court is tired of hearing about chases where people are injured. You hear about them in civil cases and criminal cases. Car chases with desperate criminal suspects are incredibly dangerous to the public at large. So he makes an effort to stop that, and then he gets out wearing the badge of his office and says, "Stop. Get out of the car. Get out of the car." 12 times in 25 seconds. Where is Mr. Blackshire's obligation to follow those commands? When that officer comes to that scene, when you talk about voluntariness, isn't he entitled to expect the voluntary cooperation of an individual to his lawful commands? And to presume that this policy was violated because he wasn't clairvoyant enough to know that this suspect, number one, was not going to comply, number two, was going to hit him with a car, number three, was going to hit him with a car again, and number four, when he tried to get him out of the car, that he would reach for a firearm, and number five, that when he tried to get to his car for safety, he would be, in effect, pursued. Remember when you watch the video, the first thing Officer Starks did was back away from the car, and the car kept coming towards him. He did not jump on the hood like a Hollywood cop. He didn't step in front of the vehicle, as Judge Hickson, you asked me for an example. He didn't step in front of that vehicle when he got out of his patrol car and say, "You get out of the car," while he's standing in front of the hood ornament. He went to the side of the car so he could aspect the suspect's hands. Hands will kill you. Watch the hands. That's replete in the record. That's his training. He knew there was a passenger in the car. Passenger's not driving the stolen car. They could be complicit in the crime, but they're not committing it at the time. The driver is the person who's going to be arrested. Officer Starks got out of his car, maintained visual on the driver. The only place he could do that was from the driver's side of the car. He didn't stand in front of the car and say, "I defy you to drive over me." That's what this policy is meant to prevent. Affirm, because you have a circuit judge who did exactly what you asked him to do and stated as such, and he reviewed the record now twice. And when he reviewed the record under Judge Barrett's instructions, he came to a different conclusion, and this court should affirm that new conclusion. Thank you.
Thank you. Mr. Edding. Four minutes and 1 second.
Thank you. Before I sit down, I'd like to talk about the discipline in this case. But before I do, I'd like to bring the court's attention to several instances in the record that I think are pretty impactful, that demonstrate that Officer Starks' actions on that day were voluntary because, again, as I said, they were conscious, they were purposeful, and they were done with intent. Particularly on page 220 in the record, he testifies that he moved toward the front of the vehicle in an attempt to get back to his own vehicle. I mean, this demonstrates that he's conscious of where his patrol vehicle is, and he has a purpose for moving in that direction. And I think that probably the most powerful of these examples is found on page 240 of the record. And there, Officer Starks is testifying about after the car has bumped him a second time, and he says that that's the moment I stepped in front of the car, but not to continue deadly force, but to get to cover. That demonstrates an awareness of where he is, that demonstrates a purpose for his movement. And then he says it was to get behind cover. Then he further testifies the vehicle continued forward. The pause was very, very, he says, momentarily, very short. Then he says that the vehicle continued forward once I was in front of it, and I continued to fire. The general order not only prohibits an officer from entering into the path of an oncoming vehicle. That general order also requires an officer to get out of the way of an oncoming vehicle if possible, rather than firing into it. Now, that video, I said that video is worth a million words at least, demonstrates much better than I could with words how possible it was for Officer Starks to just to step aside like a matador or to a bull coming into his direction.
If I'm wrong, correct me, but he also sees him reaching for a gun, correct, at the same time?
That's what Officer Starks...
So is he supposed to turn his back at that point? What's he
No,
supposed to...
I'm not at all saying he's supposed to turn his back to the car.
Okay.
But he's supposed to step out of the car's path.
But what about the suspect reaching for the gun? Have I got that fact wrong? I thought the car's moving, and he's also reaching for a gun, he believes it.
The car's moving, and it's undisputed that Officer Starks believes that the suspect's reaching for a gun with his right hand.
Okay.
And then
Before we leave here, can you address whether 303 is applicable to this episode? You heard Mr. LoRusso say it's not even applicable. How do you say this is applicable to this situation?
I think that it is, because if you see in the video and you juxtapose that video with Officer Starks' testimony, although the oncoming vehicle is not moving at a high rate of speed, it's still coming into Officer Starks' direction. So that makes it an oncoming vehicle. And any time, and we would all agree, and it's undisputed in the record that an oncoming vehicle, that impact could be deadly force. So given those two scenarios, the vehicle moving, a moving vehicle constituting deadly force, that clearly places this situation within the ambit of 303.
All right, Mr. Eddings, unfortunately, we're out of time. Thank you all very much. Very good oral argument. You've helped us out. And unless there's something else, we're adjourned.
Thank you.